During the plenary sitting of the Parliament of Uganda, the Attorney General of the Republic of Uganda, Chiwawa Kiwanuka, was asked an important but yet crucial question. The Constitutional Court has struck out sections of the Computer Misuse Act. What steps is government going to do from henceforth? What is the Computer Misuse Act and where does it come from? Originally commenced on 15th of April 2011, it was an act that was meant to provide for cybersecurity. What this means is that it was an act that was meant to protect and preserve your online transactions. It was an act that was meant to prevent the misuse of computers. But in 2022, something changed. During this year, the Parliament was able to pass what is commonly known as the Mohammed Seriko Bill, the Computer Misuse Amendment Bill of 2022. It was a bill that was meant to bring in a new realm or to diversify the application of the act. In this bill, the Computer Misuse Act brought in new offenses known as online hate speech. So we saw a transition of an act that was meant for cybersecurity getting into the realm of online expression. This was what the Uganda Law Society challenged in what came to be known as the Constitutional Petition number 42 of 2022, Uganda Law Society versus the Attorney General. The ruling came on 17th March 2026, wherein a panel of 5 justices led by Justice Irene Muria-Gonja held that during the time of the passing of the amendment bill, certain rules of procedure of the Parliament of Uganda were not followed. In particular, Rule 24.3, which states that before the voting on a bill, there must be a confirmation on the requisite quorum that is required. The court went on to hold that since this rule was not obeyed or followed to the dot, it only meant that the passing of the bill was in direct contravention of Articles 88 and 89 of the Constitutional Republic of Uganda. And as a result, the entire amendment bill of the Computer Misuse Act was declared null and void up to the extent of its inconsistency with the rules of procedure enshrined within the articles of the Constitution. The sections that were struck out were sections 11, 23, 26, 27, 28, and 29 of the Computer Misuse Act. The implication of this ruling was that court issued a injunction against all organs of government and all agencies of government, stopping them from further doing any kind of prosecution from these said provisions. The necessary implication of that would simply mean that for every single person that has been imprisoned under the provisions that were struck out had to be released or discharged immediately. This then begs a very, very important question. How about those people that were charged and sentenced under the Computer Misuse Act from the time of its enactment on 14th October 2022? The Uganda Law Society has further gone on to release a statement asking about the release, as it should be, of the people that were arrested under the Computer Misuse Act. Those include Male Mabirizi, those include Pressure 24/7, Ibrahim Musana. Fast forward on 1st of April 2026, during the plenary sitting of the Parliament of the Republic of Uganda, the Attorney General was asked a question in reference to the judgment and was asked on whether or what are the steps that government wants to do coming forward. The Attorney General quickly responded, and in his submission, he said that indeed those said sections of the law were struck out. But he then gave a warning to the general public that what was struck out were just sections of the law, that the entire remaining parts of Chapter 96 of the Computer Misuse Act are still good law. What that means is that the remaining sections are enough to ensure a prosecution or a conviction. Then he later on went on to add to that quickly, and he said that there is a new amendment that is coming up to the Computer Misuse Act under the Ministry of ICT, that this time it will be passed and it will be able to follow the requisite quorum. Why is this not over? Many people in the general public have received this ruling as the death of the Computer Misuse Act. It is not. As we have been able to see, what was struck out or declared non-constitutional are just a few provisions of the entire act. The comments of the Attorney General have been able to point us to the fact that the entire Computer Misuse Act is still alive and it is still standing. We have seen this before where particular provisions are brought back to Parliament in a different form. An amendment has been promised to come from the Ministry of ICT. To many that think this is a victory, yes, it looks like a victory on surface, but it is not a guarantee to the protection of the rights as you might know them. Thank you so much. For more information, please visit us on our website at Parliament Watch Uganda.